Good morning. Welcome to the second half of our webinar on mediation in high conflict family law cases. I'm Susan O'Toole, a family law attorney here at Beresford Booth, and I'm joined this morning by three respected and experienced mediators who are going to share some of their knowledge and experience with us. Judge Helen Halpert, Judge Michael Downs, and Mr. Soloman Kim. So to begin with, could each of you please tell us a little bit about your background and what about your background and skills makes you a good mediator?
I'll go first. I'm a retired King County Superior Court judge. And before that, I served as a judge at Seattle Municipal Court for 10 years, which is a very high volume kind of case. And before that, I was on the faculty at UW and also was an adjunct faculty member at Seattle U teaching community property. So I have a lot of subject matter expertise in this area. I to the extent I am a good mediator, I think, which I hope, I think because I'm pretty good at figuring out what the real issue is and trying to respond to what that is, and not necessarily simply the legal dispute, because they're often different.
Okay. Mr. Kim?
So thank you for this opportunity to speak, first and foremost, and I'd like to welcome everyone. My background is I became a lawyer since 1995. So I've been practicing for over 25 years. And during that time, family law was one of the first practices that I started to engage in. And being part of that, mediations were, again, essential for all my cases if we were going to be moving forward or attempting to resolve cases. And in those 25 years, having sat with my clients in the mediation rooms while mediation is occurring, I've come to realize that mediation is a very powerful, effective tool. If you can prepare and be ready for this, it can bring resolution, and that resolution is an important part of this journey of divorce and representing clients. So my background is one where it's just been something I've been doing with my clients, and eventually I decided I want to be the mediator and learn the process. Because I was only seeing it from one side, and now having mediated cases on my own and being a mediator as part of my practice, it has added a dimension both in just my mediation work, but also when I represent clients still to this day.
Thank you. Judge Downs?
Sure. My name is Michael Downs. I'm a retired Snohomish County Superior Court judge. I was a Superior Court judge for about 14 years. I moved to the state of Washington in very early 1976, having come from Boston by way of El Paso, Texas. I went to school in Texas for a while, and then I came up here, and I ended up attending what at the time was Western Washington State College. While I was a judge, I honestly don't have any idea how many dissolution cases I handled. I'm sure I did more than several hundred divorce trials, and I have no clue how many pre-trial motion hearings I heard in divorces. It had to have been in the thousands. I just never kept track. To be honest, I never gave all that much thought to being a mediator until when I was getting ready to retire. Somebody approached me, a retired judge approached me and talked to me about it and suggested that I, might give it a try and I might be good at it. And I began to do it about 4 years ago. And what I find most important about it is the human element. These are people who are in a difficult situation. They're often in a lot of pain. This might sound a little bit odd, but I find my background as having been a bartender before I went to law school actually very helpful in the mediation process, because I can just talk to people at a very basic level. Mm-hmm. And so I think my background, both as a bartender and other varied jobs I had before I went to law school, as well as my experience on the bench, and just liking dealing with people, because this is a very people-oriented thing. Just liking dealing with people is a pretty important part of my background that I think personally is very helpful to a mediator in trying to help people sort through on their own, well, on their own with a little assistance, how to resolve the very difficult situation they find themselves.
Okay, thank you all. So would anybody like to respond to what the other said at this point, or?
No,
Okay.
I don't have anything to add to what either of my colleagues mentioned.
All right. So second question, what is your mediation philosophy and how would you compare it to the philosophy of other mediators? Mr. Kim?
One thing I took away from my practicum experience over at the Everett Volunteers of America program that I completed was they had a mantra, and the mantra was that the mediators, because in those mediations you have two mediators working with two individuals that are there seeking help in their mediation, but the two mediators should not be the hardest people working in that room. And what that means is basically you can be in a situation where the two parties, the two sides are engaging each other in such a way or not. And then the mediator is really struggling to find the right questions or to find the right approach or to really open up more discussion, negotiations. And that struggle can start to really wear on the mediator. And the pressure seems to almost build inside of you. And when that happens, then the power dynamics of who the individuals are and what they're there for becomes a little bit clouded or lost. And so the mantra of the mediator should not be the hardest working individuals in the room is something that I try to adopt and apply in the mediations that I conduct, where I do strongly wish and want and desire, and I'll say that up front to the two parties, that my goal is there to help them try and reach resolution. But it is going to come not from me necessarily making that happen. It's going to happen more because the two sides are the ones that are going to struggle with their issues. And the two sides are the ones going to be having that moment, which every mediation has, that moment of, I don't want to be here, but I'm being asked or pushed to consider more or to compromise more. There is that line in the sand that everyone is pushed beyond in every mediation I've ever sat through or even conducted. And so that is that moment of reckoning. And so the philosophy of get them ready. You are the ones that are going to do the hard work today. I will be there with you and I will work as hard as I can to help you. But it's going to be your ultimate decision and your ultimate efforts that are going to get it done today. So that's how I approach mine.
Thank you. Judge Downs?
Until I saw this question written in advance, I never gave a lot of thought to what my mediation philosophy is. I guess my brain doesn't really work in that way. But having heard what Soloman just had to say, I agree and I echo that it's the parties who are involved who have to make the decisions. And I make it really clear right up front that while many local court rules require parties to go to mediation unless the court waives it, they're required to be here, but they're not required to agree to anything. And if they choose to agree to something, that's their decision. And I tell this, one of the first things I tell them, and that they may make they may be put in the position of making some decisions that are very difficult. And they might wish during the course of the process that, they really weren't here and really didn't have to make that decision. But in the end, it's their call. In terms of, general philosophy, I try to talk to people in normal, everyday language, and treat them as normal people and do the best I can. It's a difficult realm to be trying to put somebody at ease. But people come in and they're very anxious, they're very nervous, and I do what I can do to try to maybe help them relax a little bit, let them know it's okay to ask questions, but of course it's their lawyer that's going to have to answer the questions. I emphasize that I'm neutral and I'm as honest as I can be with them throughout the whole process. I don't tell people things during mediations that I think they want to hear. It's not helpful to them. To the degree that a mediator can tell anybody anything, or suggest, well, you might want to consider this and you might want to consider that. If you're telling them what they want to hear, if you're just ratifying whatever's going on in their head, that's not helping them resolve the issue. So I try to be open, I try to be honest, I try to be direct. Most importantly, I try all the time to treat the people who are involved with dignity and with respect. Because again, I know I said this earlier, but and it may be a common theme here for me today, but these people are frequently in a lot of pain, going through very difficult situations. And most of the time are doing the best they can to try to get it resolved. So that's pretty much it.
Thank you, Your Honor. Judge Halpert?
I think mediation is really teaching people how to compromise and how to determine in terms of their own values what compromises make sense for them. That the whole process of mediation is a compromise. I personally don't think being a bully is helpful as a mediator. And I do all my mediations with both sides in separate rooms, so they're not getting bullied by the other side. But I just try to be protective. It's a terrible day for people to have to come to be in mediation. They don't do this unless they can't work it out themselves. And they're dealing in family law with, most of them wish they weren't here. Somebody in that marriage probably wanted to still be married. And I think you have to be respectful of that.
Thank you. So what kind of preparation do each of you do for mediation? Judge Downs, do you want to start on this one?
Well, the type of preparation that you can do in any case is heavily dependent on what is submitted to you in advance. And quite honestly, I engage in mediations only in cases where both sides are represented. I just have concerns about being involved in other cases. Many mediators do, but I mean, don't have those concerns, and I fully respect that, but I only engage in cases where there are lawyers involved. And I encourage the lawyers to get me whatever materials they want me to read ahead of time. Because the farther ahead of time, the further ahead of time that I can get the materials, the better off it is for me as a mediator to think, if I receive them a few days in advance and the information can just percolate in the back of my head, what's the best way to approach this situation to try to see if these people can reach a resolution? A lot of times, if you're out for a walk or you're working out or whatnot, some idea will just kind of, land in your head that this may be helpful in this particular case. On the other hand, if I get them at the last second, like I've gone to mediations where I don't get something from somebody until 2 minutes before it starts. Well, then you're trying to introduce yourself to people, and you're trying to also assimilate what they just told you. You don't really have time to kind of think it through. Again, it's not my decision to make. And I tell people in mediation, mediations. It's not my place to tell you what to do. I won't tell you what to do. But again, the farther in advance I have the things so that I can read them and I can, just kind of let it percolate in my head, it's really helpful to have them. So that's the way I prepare. If I need to look up a case, if an attorney makes some representation and it appears there's some hot legal issue in the case, which of course I can't decide anyway, but if there is, I may go read a case that's pointed out to me or something like that. But for the most part, it's just the factual situations. Who are these people? And what might be helpful to them, and maybe what not to raise with them. Sometimes you got to be pretty careful that you don't say something in a mediation that causes the whole thing to blow up. That's the last thing you want as a mediator, is to be responsible for that happening. So again, information in advance, and you're dependent on the parties and the lawyers to give that to you. That's what I do.
Okay, thank you. Judge Halpert?
It's pretty similar. Mostly it's getting familiar with the facts and thinking about how the law applies to the facts, reading what's presented. But I will, if it's an area I haven't done a lot of work in, I'll just do some independent legal research to make sure that I have an accurate way to evaluate a case, because really mediation is sort of two parts. One is getting the parties to think about what they want and what's realistic. And quite often, then they'll say, well, what do you think would happen in court? And I want to be able to answer that question.
Okay, excellent. Mr. Kim?
So similar to what both judges have described, and the importance of getting information before you start. The morning of, if you have nothing from one side and then you have some materials from the other side, it does create a bit of a lopsided starting point. Now, I think like both judges will ask both sides to provide whatever written materials they want me to consider. And if I am able to get both, then what I end up doing is I will actually just do a chart. I'll draw a line through my notepad and I'll put down one side on each column, and then I will write or note what I understand are important facts or details. And then I'll try to compare them to see if there's any agreement points that are either there or that could be there. Because for me, mediations are all about trying to find nuggets of agreement points. If there is an agreement that can be reached, even if it might be as small as, each side takes one vehicle and the other takes the other, it's an agreement point. And I want to capture those, because what those small agreement points can create is sort of a momentum. And so that is what I try to do, is to find, before the mediation may start, agreements that I think are there, and then maybe even ask the parties. This is what I've seen from your materials, party A, and from party B, these are information or details you provided, and it seems like these are areas that you both agree. I mean, sometimes they'll just say it. Parenting can be done by co-parenting the child or children together, and then that's great. Then we capture that, and then we can add that to this list of agreements that we're trying to accomplish for that day, because then it does, again, create that momentum. So for me, seeing and noting where the agreements start to develop are very helpful to start putting together the CR2A, the final document that will hopefully be what will get the mediation done and completed and the parties settled. So that's my approach.
Thank you. Judge Downs, you said you don't do mediations where the parties aren't represented by attorneys. So maybe you could kind of tell a little bit more about why that's your position. And Judge Halpert, Mr. Kim, the next question was, what parties do attorneys play in mediation, and do you do things differently if the parties are not represented by attorneys? Judge Halpert, do you want to begin on this one?
Sure, I think it's very difficult as a mediator, particularly in family law, to keep that neutral role and not to turn into the de facto attorney for the non-represented party. And I think that's something I try to keep in mind. But I also firmly believe an agreement that fundamentally is unfair is not going to be in the best interest of the kids and isn't going to hold up. So there's kind of a line there. I talk to both sides ahead of time. With the lawyers, it's a chance for them to talk to me confidentially about how they view the case without their client present, without anybody else present, ideas for how to approach their client. And I use the time usually with the, if there's a pro se, explaining in greater detail what a mediation is and how what their reasonable expectations are.
Okay. Mr. Kim?
I enjoy when lawyers are involved on both sides because I can somewhat rely on them to provide the legal advice and to address some of the questions that do come up. But when there is situations where only one side has an attorney and the other side does not, I agree with Judge Halpert that the pro se or the individual without their attorney, they are at a disadvantage. But I also must adhere to the obligation that I have to both parties to try to remain neutral and to try and just explain to a certain extent so that there's an understanding, but to be very mindful that I cannot and I should not and I must not be leaning in a either advocate or preferential to the individual that doesn't have an attorney. Now, when I've when I've mediated cases where both sides have no attorneys, that is also a challenge because they are both having some degree of information that they may have researched on the internet or talked to people or families. They will come in with some ideas and they'll just say something like, all my stuff is mine, right? And then I think as a mediator, to not give legal advice, but more so to try and explain what the law is. And of course, ultimately telling both sides, if you're not understanding this, then you really should and you must go talk to an attorney, but to do it very openly to both of them. But attorneys are very helpful just because they are going to be the source of the answers that sometimes the client needs or the party needs. And I always, when I speak to the two individuals, the attorney and the party, I always will emphasize that you both must today work together. I will do my part, but you both have a job to do. And the job is to be prepared to talk about whatever it is that's important and then to understand what the ramifications are, because I, as a mediator, should not be explaining that if you don't do this or do that, these options will turn out this way or that way. That's more, again, what ultimately a judge will do if you can't figure it out today. So having lawyers is definitely makes the process better or somewhat easier to not have to explain so much. But sometimes lawyers, depending on maybe how they've prepared or not prepared their clients, can actually make the process a bit more challenging as well, I found. So it's not always a 100% scenario, but it does make it better and simpler and easier for me as a mediator in my role when lawyers are present.
Okay, Judge Downs?
So you wanted to know why I don't mediate cases unless both sides have lawyers. As a mediator, my job is to be as neutral as I can possibly be and go back and forth between both sides for as long as it takes to see if it's possible for the parties to reach a resolution. And I stress throughout the day, I'm neutral. I tell people very directly, even though it sounds a little awkward, I think, I tell people, you have to understand I'm not on your side, but I'm not on your husband's side either. My job is to be as neutral as I could possibly be and go back and forth between both sides. And I'm concerned, I mean, very honestly, I have the luxury of being able to make this call myself. This is a decision that I've made from my mediation practice, and I know that many mediators do things differently, and I'm not at all critical of that. I'm only talking about me. I am concerned that if I'm answering questions for people, that when all is said and done, somehow or other, they're going to think that I was representing them and that I was their lawyer, and I'm not. And they ask all kinds of questions. You know, I get asked a lot of questions in mediation, and my answer to it is, well, you know, that's really something you need to talk to your attorney about, because the answer to that is really legal advice. And I can't give you any legal advice. I make it really clear to people, I cannot give you legal advice. The written agreement that they sign for me to be engaged in this mediation is that I'm not acting as an attorney. And so I do it because or don't do it, because the roles are more clear. They know what my role is. They know that I'm neutral. They know that their attorney represents them and not that I don't. In terms of having lawyers be prepared, I agree with something Mr. Kim just said. You know, sometimes lawyers, it's golden to have them there, particularly people who are, you know, pretty good at what they do and who have a good relationship with their client and who are not shy about telling their client, well, you know, you need to stop for a minute and ask yourself, how likely are we to be able to prevail on something in trial? Because in my experience as an attorney, we're going to have a very difficult time convincing a judge of X or Y or Z. Okay, that's the lawyer's job. Now, I've seen lawyers who kind of, doesn't happen often, but who kind of puff up during mediations, and you know that isn't maybe great for being a trial lawyer, but it's not perhaps conducive to settling cases in mediation. So I think it's very important to have them involved. I think that the clients, the people who are involved in the mediation, if they turn to somebody who they know is on their side, and they ask that person a question, and that person gives them an objective answer, I think they can have maybe more comfort in what they're being told. They certainly have more assistance in what they're being told. The lion's share of my not doing it is, I know full well I can't give them legal advice. And I'm very concerned that if I was mediating cases that people weren't represented, there'd be times when you're skating so close to the edge that I'm personally not comfortable with it. Now, again, many highly knowledgeable, skilled mediators are comfortable with that, and I take nothing away from their position. It just isn't for me.
Okay. So the next question, what are some of the most important things you hope will come out of a mediation? Mr. Kim?
For me, whether a mediation ends up with a final settlement is kind of the icing on top. If I can help and be part of that process to get them to a final settlement that everyone signs and we have the CR2A fully executed, I mean, that is the ultimate goal. But I think another just as important hope and goal that I carry into mediations when I am involved is I am hoping that the parties will, from the mediation process, be able to maybe get better at communication or at least understanding the other side. I mean, I do have the ability as a mediator to go from one room to the other. And it's often amazingly different how the perception of one room thinks and feels about the other. And there are often times that I'll find that there is a theme of concern that is there, but there's been a breakdown in their communication or trust, that there just isn't their openness, their door has been shut, basically. And so if I can open that up somewhat, again, not because I'm telling them they must, but if just from the mediation process, either when they're two individuals that are unrepresented or even with attorneys, If communication or maybe even a small crack of trust can be open, I think that's what I also hope for from mediations that I have been involved with, and that mediations that I've also represented clients where the mediator does an excellent job of doing that in our room. They come with a bit of information. And I'll tell you, one time a mediator came back and told my client, the other parent thinks you're a good parent. And that's all my client needed to really hear, the affirmation that she is a good mother, and that the husband believes that and knows that. And that really was important. That little bit of information carried over and shared in our room was a message that really brought the temperature way down. I mean, it was hot, everyone was tense, anxious, and upset. But once that was shared and known and affirmed, and then of course we said, well, we also believe that the other parent is a good parent and that they trust that parent. That really did. It changed the whole shift of the parenting issues that were in dispute. So communication is just a hope of a excellent byproduct of the mediations that I try to help out and work out for the parties involved.
Thank you. Judge Downs?
Well, the point of going to mediation is to try to resolve the case in a manner that both sides can live with. It may not be their first choice, and they might have to swallow hard to make some decisions. They might have to say to themselves, well, I really don't like this all that much, but okay, I can live with it.
Mhm.
The point is to get to a resolution if they can get to it. And I've spoken to people about that during mediations. Something will come up and somebody will make a comment, and I will say to them, well, of course I want you to resolve the case. I mean, what kind of a mediator would I be if I walked into mediations and none of the cases ever got resolved? I mean, there wouldn't be much point in my even being here. So the important thing, I suppose the important thing is to try to get the case resolved. But as Mr. Kim just pointed out, there are other things too. You know, particularly where there are children involved. These adults, for whatever reason, have chosen to go their own way, and pursuant to Washington state law, they're entitled to do that. But I've had conversations, some like Soloman Kim just mentioned, where someone will say something in one room and you repeat it in the other, and it kind of breaks the ice. But I've also had conversations with people where I tell them, I understand that the parenting plan ends when the children get to be adults. But that doesn't mean that when the children gets to be adults, your involvement with each other is over. Y'all are joined at the hip for a long time. There may be grandchildren. There may be a wedding. There may be graduations. You guys are hopefully going to have to find some way to at least grudgingly respect each other to get through all of these life's events. And so if that can come out of a mediation, if not just the bare fact of the resolution itself, but if some kind of agreed upon or some approach can be reached going forward for, forever sounds crazy, but it really is forever, then that is, to me, that's really important as well. Because these people are human. This is the most human of endeavors. When they're not going to feel good the day that, well, some people might, but most people aren't going to feel good the day they get divorced, but they need to keep moving. They need to live their lives. And they need to know that, they just need to know they can do it and keep trying to work together, even if they had to split up for whatever reason. So that's what I would say.
Thank you. Judge Halpert?
Well, I just wanted to turn this back a little bit to the concept high conflict divorces, because that's really what we came here to talk about. And often those cases involve domestic violence. They can easily involve substance abuse, or they can involve my people with personality disorders who are very hard to work with. And I think knowing what is realistic and what is not realistic in a really high conflict divorce, it may not be a kumbaya moment. What you may come up with is a plan, a reasonable parenting plan with a case manager who's going to have to manage the ongoing conflict. It may be that you're going to be doing lots of little arbitrations until people get able to make decisions together. I think it's really important if it's been a case with a lot of conflict, to try and move the parties off of that. And that's why I think it's very helpful if the lawyers let you know ahead of time why they think it is a particularly high conflict case, so that you can think about it a lot. You can think about if one of the clients has a mental illness of some kind. Well, you just need to approach that a different way than other cases. And it doesn't mean that person might not be able to parent, but you do need to sort of figure out what you're doing with it. So that's what I wanted to talk about, is a little bit about the high conflict. I would never have those folks in the same room. When I do cases with DV, or in most of the time, I'll excuse one room first, wait 10 minutes, and then excuse the other, so that these people don't have to worry about seeing each other.
Okay, thank you very much. So next question, recognizing the need for confidentiality, can you tell us generally what have been some of your most interesting, challenging, or rewarding mediations, and why? Judge Downs?
Well, that's kind of hard to say. I've mediated a number of different types of cases, and it'd probably be pretty difficult to talk about the most difficult ones without them becoming fairly obviously the ones I was talking about. I mean, the people involved would probably recognize themselves, and I'm a little bit concerned about, walking over confidentiality with that. So I don't know that I have any particular story or parable to offer in that regard that I'd be comfortable making public. Sorry to duck, but that's kind of.
That's okay. That's absolutely fine. I understand that. Well, is there anything without, are there any mediations without getting, beyond what you feel comfortable with, where, the outcomes have particularly pleased you because of something that was accomplished, or that you could just talk about that thing?
Well, just generally speaking, I've gone into a lot of mediations that settled, and I've had the attorneys tell me afterwards, wow, nobody thought it was going to settle. That happens not infrequently. And I think, I spoke about this earlier. People are nervous. People are anxious. Some people, Judge Halpert just touched on this. Some people come in and they maybe want to be a little bit of a bully. And, quite honestly, being a bully doesn't work with me. It just doesn't. I grew up in a big city, and I was a bartender, and I had to exercise some bouncing responsibilities in places where I worked, and I oversaw some very contentious trials, and I was involved in some very contentious trials as a trial lawyer. And that just doesn't work. So again, I had a case, I'll give you one example. I had a case one time, and I did this as a settlement conference when I was still working, of someone, no, actually I can't do it. Sorry about that.
That's all right. I understand. I knew when I wrote the question that we might not have a whole lot of examples, just for that very reason, that everything is confidential in mediation. And actually, that I think is one of the most comforting things to people coming into mediation, is that it never goes beyond those four walls. You can't use it in court, and it never goes any further. So I don't know, Judge Halpert, do you have anything that you feel comfortable sharing?
No, but I guess what I will say is the mediator needs to be willing to pull, recess when things have gotten, when people are so upset that you can't really be comfortable, that even though they have counsel, that their decision-making is from their rational part of their brain, not the lizard part. I think you have to be willing to say, let's come back. Let's come back. And I think sometimes early on, you can look at a case and think there's just no way this can be done in one day. They have, complicated money issues, and they have complicated child issues, and you can bite it. That's something you can make a decision on sometime soon. And that just takes some pressure off. But I do think the mediator has an independent ethical obligation. Even though we really want to get these cases solved, if someone is sobbing in their room and they're saying, I can't do it and I can't do it, and the attorney's saying, oh, come on, we've only, I will raise the issue.
Okay, and when you do that, is it like an hour away, or is it like several days later? Are you talking another mediation session?
We'll see. I mean, sort of, but not an hour away. Usually this doesn't happen. It's already 9 o'clock at night.
Mm.
And
I'm sorry, Judge Halpert, I didn't understand what you said. May have been something with my computer. Would you mind repeating that last portion of your answer?
Sometimes, early on that it's too ambitious to try and do a case in 7 hours. And I will raise that early on. I'll say, let's start with the parenting. And then we'll move. And if we get that resolved, let's move on to the money. But it might be we're not going to be able to do it together. And I really hate when people want to hold parenting hostage to money. They're pretty different issues. But I also think that a mediator, the lawyers have a pretty big impetus to getting these things resolved too, and to controlling their calendars. And I don't think a lawyer would ever intentionally make this decision. But I think once somebody's crying pretty hard, it's time to take at least a short break and maybe to call it a day, depending on how late it is. Or at least to talk to the lawyer about it privately.
Yeah. Mr. Kim, how about you? Do you have anything you feel comfortable talking about, or would you like to just respond?
I looked through some of the cases that I've mediated now over the past 3 years, and my mediation practice isn't necessarily high volume, but I've had an opportunity to be involved in several cases. And the one that I was looking through the list of them, the one that jumps out is the first mediation I conducted by myself after my training through the practicum at the Volunteers of America. And it was two individuals. It was a family case, two individuals that did not have attorneys, but they just felt like they wanted to give it a try. And so we sat down and we started doing 3-hour sessions. And I approached it the way the training was that I learned, and found that as we were doing these 3-hour block sessions, things were starting to come together. But it was very, very difficult because they had very different backgrounds and they were trying to address all issues. They had children and how to deal with them. And of course, the mantra that I mentioned of I shouldn't be the hardest person mediator working in the room really did allow both of them and this was before COVID, so we were in this conference room. They're both sitting on either side of the conference table, and I'm in the middle, and we're talking about things and we're working through it. And eventually, after 5 sessions, we reached the finish line, and that was very deeply satisfying to have helped them get there. And that one case was a positive experience, to see individuals that came from very different ends and trying to address all of the big issues that they had to, and then for them to struggle together and to get there was very meaningful and memorable. And then, of course, I'm sure the judges have both mentioned it, I've had some marathon sessions that went 14 hours. I mean, it was insane. I mean, I was about to lose my mind, and the parties and their lawyers were all at their wits' end, but they just still wanted to keep going because they were making tiny movements, but it was still moving and it wasn't stuck. And yeah, 14-hour mediations are intensive. I feel like I've been through a 2-week trial, but to get it done, everyone signs and it is finished, is again that sense of I was part of this, and it was successful to get them to that finish line of the CR2A agreement is always a deeply satisfying moment, and hopefully for everyone involved as well.
Okay, thank you. All right, this has been really wonderful. Thank you both. Thank you all so much. Do you have any closing comments? Anything that you would like people to take away? Judge Halpert?
No, I think mediation early on can be really helpful before you've spent a huge amount of money on discovery, before positions get completely calcified. It's a good time to mediate. Sometimes people mediate temporary orders because it's a way just to get some movement on the case. And once you work well with your temporary orders, it's easier to get final orders. So I think I'm a fan of early cooperative mediation.
Okay, excellent. Mr. Kim?
I had the thought in my mind a second ago, but it's starting to. But what was the question? Just final thoughts.
Final thoughts.
I am a huge proponent for mediation. That's what I wanted to say. I am a strong believer that mediation works. If the parties come in prepared, I mean, that's really the key. They must come in prepared. They must understand that they're going to be asked to make tough decisions about that day, and that day is the opportunity that they have. But I have seen it in my years being an attorney with my client and us getting to resolution or settlement, and now as a mediator, helping get to that resolution and settlement is such a relief, and you can just see it from their shoulders and just their expressions. They're not happy. Most people aren't happy, and I think Judge Downs mentioned it. They're not there because they're excited. They're there because they're kind of almost forced, but they've made that tough decision. I don't like it, but I can live with it. And just that sense of closure is something that I think is a wonderful thing. I really do. And I say it openly to as many people as I can, not just because I'm a mediator, but I believe in mediation as a very powerful tool to help people find closure and the ability to move forward in their lives. So that's it.
Excellent. Judge Downs?
Kind of along the lines of what Mr. Kim just said. Most people can live better with a decision if it's a decision that they make themselves, rather than someone telling them, this is what you have to do. They're just more at peace with it. Even if it's a decision that they might not be wild about them making, they still made it themselves. So I talk to people about that actually along the process of, if this is a decision that you can make, rather than have Judge Smith say, you have to do this, it just generally goes down better and people are more comfortable with it. They're more comfortable that somehow or other they own it or they're responsible for it. And so mediation, I think, is really good in that regard if people can bring themselves to reach an agreement. Now, they don't always succeed. But if people can do it, then it's I think, a better way. It's certainly less expensive. It's certainly less contentious than a trial. It resolves the case much more efficiently and much more quickly. I mean, if you go to trial, then you have to wait for the decision of the judge, and then you got to wait and see if the other side appeals. And if the other side appeals, you got to wait on the Court of Appeals, and that can add very lengthy periods of time to the litigation, not to mention significant amounts of money. So I'm a fan of mediation for those reasons, because I think it just makes people more at peace. If they agree, it makes people more at peace with the resolution of the case, which isn't the same thing as to say they're totally peaceful about it or totally at ease about it, but they're more at ease about it.
Yeah, I agree. All right. Well, thank you all so very, very much for your time out of your busy schedules. This has really been wonderful. And I think that the people that view this will take a lot away from it. Thank you all very, very much. Take
All right,
care. Bye-bye.
Take care. Thank you for inviting me.
Bye.
Bye-bye.